My name is Eric Humildad, and this is a case study of defamation. The two cases that will be reviewed are the New York Times versus Sullivan and Gertz versus Welch. Part 1, New York Times versus Sullivan. The parties involved in the case include the plaintiff, L.B. Sullivan, commissioner of the Montgomery Police Department, and the defendant is the New York Times newspaper for publishing the advertisement Heeding Their Voices. Now, the facts that led to the dispute would include the publishing of the advertisement by New York Times, Heeding the Voices, that happened to describe the action of the law enforcement during the time of civil rights movement. And as a result of what was printed, Sullivan sued the New York Times for libel. Some of the reasons why Sullivan felt his reputation was damaged by the New York Times would include because he was the commissioner of the Montgomery Police Department at the time, it was his duty to supervise the department. So the actions mentioned in the advertisement he claimed to be false. And he said that any mention of police action was a reflection on him. The two elements of libel that were used in this defamation case are the New York Times article that had resulted in the damages of Sullivan's reputation, and also the accusations of the Montgomery Police Department and the way they handled the crimes irresponsibly. Since Sullivan was a public official, what did the plaintiff have to prove in this case? So Sullivan had to prove that because some of the accusations were false and because the article damaged his reputation as a public official, it was done with malice. He also had to prove that the press acted outside of the First and 14th Amendment rights of speech. For the outcome of the decision by the U.S. Supreme Court and why they made the decision, well, they ruled in favor of the New York Times. In order to prove libel, Sullivan would have had to prove that the newspaper acted in malice, that they knew they were printing false information with reckless disregard of the truth. Our next case is Gertz versus Welch. And the parties involved in this case are the petitioner, Elmer Gertz, attorney for the Nelson family, whose son was shot and killed by a Chicago police officer. We also have the respondent, Robert Welch, the magazine publisher of the American Opinion, who published the article making strong accusations about Gertz. And it would appear that neither parties are public officials or public figures. So, what were the alleged defamatory statements about Gertz in the American Opinion article? The American Opinion was a monthly magazine that published views of the John Birch Society monthly. The magazine published a series of articles that claimed that Gertz orchestrated Nunzio's conviction. They also claimed that Gertz was a member of a communist organization, including the Marxist League for Industrial Democracy, which advocated violent seizure of the government. Additionally, the magazine labeled Gertz as a Leninist and communist fronter. Now, their ability to confirm the accuracy of these allegations against Gertz, well, it would appear that Walbert Welsh Incorporated, they did not investigate whether the allegations were true and made no effort to substantiate the charges that were made against Gertz. And matter of fact, some of the information that they had reported had proven to be false. It was Gertz's criminal record that he had ties to communist organizations and that he was a Leninist and communist fronter. As far as Gertz's reputation, well, Gertz's reputation was damaged as far as his ability to obtain new clients as an attorney and lecturer, and also his personal and professional reputation as a scholar and professional attorney. Now, what we could have done differently in the Welch case to avoid the lawsuit, well, we have to look at it like even though the magazine showcased these opinions, it should not have treated their negative bias as truth, because accurate facts should have been reported along the way with negative opinions if that was the target. The research should had been conducted before distributing inaccurate information. In past tense, the best advice I take from studying these two cases and 3 weeks of class so far would be is to make sure that all the facts line up, everything is truthful. You know, separate the fantasy from fiction, and know when to delineate between opinion and fact, and I guess would say known when not to go on the offensive. In California, the defamation laws, there's two types of defamation: libel for anything written and slander for anything verbal. According to the California Civil Code Section 45 and 46, for libel, the communication must expose the plaintiff to hatred, contempt, ridicule, which caused him to be shunned or avoided, or which has a tendency to injure him in his occupation. As far as slander, the communications must charge the plaintiff with the crime, impute him with an infectious, contagious, or loathsome disease, or tends directly to injure the plaintiff in his occupation. In order to prove a libel or slander claim, one must prove false communication, unprivileged statement of fact, not opinion, that it was made about the plaintiff, that it was published to a third party, and that it caused damage to the plaintiff. How can you relate to what you learned from Sullivan and Gertz's case to your future work in the communications industry? It was like I said when I did my little reflection piece. You must always use your accurate sources when you write a story. You have to research all the information and the facts before it gets published. You have to obtain all the information from the parties involved so that you can back up your information with some substantial facts and real meat.